Donald Trump and his defense filed their opening brief in the D.C. Circuit Court of Appeals, and we've been going through this appellate process for quite some time. We know that Jack Smith just got the Merry Christmas backhand. Sorry, Jack, you can't jump over the line here in the Court of Appeals. You have to go and file the appeal through the Court of Appeals, and then you can hit our court. So Trump is now filing this in the Court of Appeals, and we've got some reaction from some other people, including Trump's former attorney, James Trusty, on what happened with the SCOTUS denial. So we'll go into this, but let's get started with the Court of Appeals argument. You see, oral argument is currently scheduled for January 9th. The court is the District of Columbia, the D.C. Circuit, for the United States of America versus Donald J. Trump. This is the opening brief of Donald Trump. The usual people here working on behalf of Trump, John Lauro and Todd Blanche, are here submitting their filings. And here is what they say. The parties, of course, we know. We've got Donald Trump. He's being prosecuted by the United States of America. We've got a bunch of amici curiae. These are friends of the court. Oh, look, it's J. Michael Luttig. That's probably Judge Luttig. Right. There it is. Donald Trump's defense writes to the Court of Appeals in the D.C. Circuit. They say, "Dear judges, Merry Christmas. During the 334 years from 1789 to 2023, they say no current or former president had ever been criminally prosecuted for official acts. Now, that unbroken tradition died this year, and the historical fallout is tremendous. The indictment of Trump threatens to launch cycles of recrimination and politically motivated prosecutions that will plague our nation for decades to come, and likely stands to shatter the very bedrock of our republic, the confidence of the American citizens in an independent judicial system." And this is something that I absolutely agree with. We've been here lamenting the downfall of our justice system, very concerned. We already know the executive branch is in the trash. We already know that Congress is like a 6% approval rating on a good day. The last thing that we had was our judicial system that hadn't been too politicized. Okay, we had, of course, abortion cases and the regular ordinary course of the judicial, ebb and flow. But what we've seen ever since January 6th, ever since the Democrats got in charge, they have just ransacked the independence of the judiciary, right? That takes decades and centuries to build up. For people to think that the judiciary is legitimate, that is evaporating overnight. This has been something that's been worked on since the beginning of our country, and now with just a couple years of damage, it's basically gone. And I don't know that it's ever going to come back, to be perfectly clear with you, which is why this next election is so important, because whoever controls the Justice Department now apparently is going to control the country. It's like capture the flag. You can now just indict your political opponents and go hog wild, and there's very little recourse. Now, we're going to see if that goes to fruition. I think it's going to backfire on them. But the point is, they're the ones who crossed the line. But here is what Trump's defense says. Under our system of separated powers, the judicial branch cannot sit in judgment over a president's official acts. The doctrine is not controversial. It was treated as self-evident and foundational from the dawn of the Republic, and it flows directly from the exclusive vesting clause of Article 2. In 1803, Chief Justice Marshall endorsed this. He wrote in the seminal case, you probably heard about it, called Marbury versus Madison, a case that's widely considered in law school to be the case that established judicial review, which is a critical thing, and then we're just, flushing all that down the toilet, that a president's official acts, quote, can never be examinable by the courts. Okay, a Chief Justice, he put it in that case. A president's official acts, quote, can never be examinable by the courts. Because that's his discretion. If the courts can say, sorry, President, you're not allowed to do that thing within your discretion, well, then that's going to mean that the court is really the president. They're the ones who get to decide. Okay, if Donald Trump had to do whatever Liz Cheney said right after January 6th and call her early, hey, Liz, are you happy with my response? She's the president, not him. If Trump has to go and call the National Archives, hi, can I please have my documents now? My classified documents, please? She says, I'm sorry, Mr. President, you have to fill out the form. Who's in charge? The president or NARA? All right, this is what we're talking about. And these people keep trying to topsy-turvy that. But they say, the structure of our government, the text of the Constitution, and its early commentators, common law immunity doctrines, our political history, the Supreme Court's analogous immunity doctrines, and the policy considerations rooted in the separation of powers all dictate that no president, current or former, may be criminally prosecuted for his, quote, official acts unless he is first impeached and convicted by the Senate. And so every time you hear one of these dementoids on, MSNBC saying, first of all, total immunity for the president. First of all, that's not what they're arguing. They're arguing immunity for official acts. You see that in italics. But then secondarily, the recourse, which they all forget about, is you just impeach him and convict him. Okay, so if the president does something insanely criminal, like that's actually actually a crime, it's a no-brainer. You just impeach him. It's, a unanimous in the House. Boom, right over to the Senate. You get maybe 3 holdouts. They all say this guy's a total criminal, right? Because the political consequences there. And once that happens, then boom, it's fair game. Indict him wherever you want. Indict him in 35 states for all I care. But you got to go through the process. So they say, nor may a president face criminal prosecution based on conduct. And Trump, by the way, was acquitted by the United States Senate. The indictment against Trump, they say, is unlawful and unconstitutional, and therefore it must be dismissed. Now, of course, we know the jurisdiction. The district court, which is Judge Chutkan, she denied Trump's claim of presidential immunity and double jeopardy in a bad filing. Trump filed a notice of appeal, and here we are. Now, here are the issues that we're really wanting to dive into and answer these questions from the Court of Appeals. Question 1, whether the president has immunity from criminal prosecution for official acts. In other words, those acts that fall within the outer perimeter of his official responsibilities. Okay, so the president is here. You've got, let's say this category, which is like absolutely articulated powers. Okay, like the president can clearly, it's going to look like Judge Engeron here in a minute, but we've got this is the absolutely, clearly the president's duties. Then you have stuff that's out here that's maybe a little bit more, like it's not as explicit, it is implicit, right? You've got stuff that, there's a really good rationale that the president can do this because the Constitution says explicitly that, and so we can logically defer to this. Similarly, here you have another operation here, and we're asking ourselves, okay, this is the outer perimeter. Maybe this is like a little gray area here. Maybe we got some questions on this. We don't know, but that's what an executive does. An executive is having to execute in new and novel situations. We ever had a country, an election where, half the former CIA rigged this with propaganda? We ever had situations where you've got massive evidence of fraud, not even on the day of the counting of the votes, but on the changing of the rules outside of the state legislatures that has the constitutional authority to set the rules. We had secretaries of states and judges all across the country changing deadlines, changing signature requirements, the whole thing. So, all of this is new and unprecedented, and Trump, in facing a new and unprecedented situation, is investigating these things. And yeah, maybe we haven't been in a situation before where the election was clearly rigged and we were censored in the run up to the election. But that's the outer perimeter. And you know what? I want my executive to enforce fair elections in this country. So I would say that is clearly within the Engeron, not outside the purview of the presidency. So that's question number 1. Now, question number 2, whether the impeachment judgment clause and the principles of double jeopardy prevent a president who's already been impeached, which you think of like the analog of being indicted, and then acquitted by the Senate for the same or closely related conduct, right? So do they have to impeach, then convict in the Senate? Trump obviously was acquitted in the Senate before they indict elsewhere. And so here is what they say. All right, Court of Appeals, just so you know, here is the statement of the case, telling us that on August 1st, President Trump was indicted. We know these counts are obstruction and conspiracy charges. 4 counts based on allegations in his efforts to dispute the outcome of the widely questioned presidential election. The indictment charges that President Trump with different crimes that are, they say, are acts of political speech and advocacy. They're charges, but that's what they are, saying that he's just disputing the election outcome after the campaign had already ended, performed while President Trump was in office. Campaign's over. Trump is literally the president. It is political speech, they say, and that's a crime. Now, the indictment alleges 5 types of conduct, all which they say are literally quintessential presidential acts. So they're within the outer perimeter, clearly. First, they say, President Trump made a series of tweets and other statements about the outcome of a federal election, contending the election was tainted by fraud and irregularities. All true. Now, second, the indictment alleges that Trump communicated with acting attorney general and officials in the DOJ who were responsible for investigating these crimes and possibly appointing a new acting attorney general. Guess what? Appointing an acting attorney general, that's the job of the president. Investigating election crimes, that's the job of the DOJ. Bill Barr didn't do much good at that. That is a division under the president. So that's a presidential act. Third, the indictment alleges that President Trump communicated with state officials about the administration of a federal election and urged them to do their dang jobs with extensive information from his perspective. And that's his mindset. Okay, that's for him to decide. Liz Cheney can say it's not relevant, or Bill Barr can do the same thing, but he's the president. They didn't get elected because their judgment is garbage and crap and they're not qualified. So we don't really care what their judgment is. Fourth, the indictment alleges that President Trump communicated with Mike Pence. Wow. So the president talks to the vice president. You're kidding. Is that a crime? Says maybe it should be for this administration, everybody for this type of stuff. Like, that's a crime? Okay. Well, what's Kamala? What's her status? Attempted to communicate with other members of Congress similarly, right? All presidential stuff. And fifth, the indictment alleges that other individuals organized slates of alternate electors from 7 states to provide a justification for Mike Pence to question and count the votes. All of that, right? Those are the 5 categories, which is basically just regular election stuff. Anyways, that's the statement of the case. Now, Trump's defense continues. They say, here is the status. On October 5th, President Trump filed a motion to dismiss the indictment. He said he had presidential immunity. He said it extends to immunity from criminal prosecution for a president's official acts. He argued all 5 classes of those conducts are within the outer perimeter of the responsibility of the president. On October 23rd, he also filed a motion to dismiss. He said, the impeachment clause, which is in the Constitution, and the principles of double jeopardy, which is also in the Constitution, say that Trump has been already acquitted and indicted for the same crime. That's double jeopardy. That's a no-no. On December 1st, the district court, Judge Chutkan, issued her memorandum opinion, and they say that Chutkan wrongfully held that a former president has no immunity for official acts while performed in office, which is an insane ruling. So the president can be charged with crimes for his official conduct in office and without even being impeached. Like, there's no impeachment mechanism there either. So 50 attorneys general or state level prosecutors like Fannie can all just decide to go indict Joe Biden under this standard if they had, any political stones to do it. Now, the court did not address Chutkan whether any of the conduct alleged in the indictment falls within the scope of his duties. The district court also incorrectly held that neither double jeopardy principles nor the impeachment clause prevent the prosecution of a president who has been acquitted. So that's Judge Chutkan, brilliant legal scholar in DC, who is just twisting and perverting the law for her own ends without considering the long-term consequences of this, because this is it. Stopping Trump is all eggs in the basket, man. It's break glass in case of emergency. The traditional judicial system is gone. It is now a tool of a politically motivated enterprise. Trump's defense continues. Here's the summary of the argument. They say, President Trump has absolute immunity for his official acts as president, and the indictment from Jack Smith alleges only official acts, and so it must be dismissed. They say 7 considerations mandate the recognition of presidential immunity from prosecution for official acts. First, criminal immunity has deep roots in the separation of powers. Look at the Constitution, Article 2, Section 1. It tells us the president is vested with executive power. The judicial branch may not sit in judgment, criminal or otherwise, of the exercise of that power. Otherwise, the court is the president. As Chief Justice Marshall wrote back in Marbury versus Madison, and this is like law school starts basically with this case in con law, and you really put a lot of emphasis on this because this was a critical juncture in the country. Like, if the court didn't get itself integrated into the process, the whole 3 branches might have gone topsy-turvy. The court may not have had enough power, and so it's kind of seen as like almost like a miracle of the courts that they got some power, and then the other branches kind of recognize it a little bit, and it's this very delicate balancing act that Judge Chutkan and the Democrats have absolutely wrecked. And the president's official acts can never be examinable by the courts. Okay, they figured this out in 1803. They were a lot more intelligent than what we have now. They say, second, the text of the Constitution through the impeachment judgment clause presupposes criminal immunity. It's in there. The clause dictates that a president may be criminally charged only if the, quote, party convicted in an impeachment trial. They put that in Article 1, Section 3, Clause 7. It says party convicted. Trump was acquitted. They say Alexander Hamilton reinforced this understanding by writing in the Federalist Papers that the president may face criminal prosecution only afterwards or subsequent to impeachment and Senate conviction. You want a political prosecution layer to make sure it's not political. It's a safety valve. Okay, this person was convicted by his own party, right, in the Senate. So that means he's really bad. So then we pull him out. Okay, he's already been convicted. Now hit him with everything you got, states and feds. But that didn't happen here. President Trump was acquitted, not convicted. Hello, by the Senate after an impeachment, so he retains immunity for his official acts. And third, early commenters on the Constitution, including Chief Justice Marshall, George Washington's Attorney General named Charles Lee, Alexander Hamilton, Justice Joseph Story, one of the most cited justices in the country, maybe the world, and others, confirmed that a president's official acts are not examinable by the judicial branch, right? They don't get to say and substitute their judgment. Neither does Congress. Fourth, at common law, immunity from criminal prosecution was far more central to the concept of immunity than immunity from civil liability. So civil liability is kind of a subsidiary of criminal prosecution. prosecution, saying here the prospect of senior officials facing, quote, criminal charges before a possibly hostile judiciary was the chief fear that official immunity was designed to prevent. Supreme Court talked about that back in 1966. Fifth, the 234-year tradition of not prosecuting presidents for official acts, despite ample motive and opportunity to do so, provides powerful evidence that the power to do so does not exist. Perhaps the most telling indication of a severe constitutional problem with this, quote, wholly unprecedented prosecution is, quote, a lack of historical precedent to support it. That's a 2020 case. They say 6, analogous, similar immunity doctrines for legislatures and judges, which are also rooted in a separation of powers, support criminal immunity for a president's official acts as well. Legislative immunity prevents legislative acts from being made the basis of a criminal charge, right? So if they have legislative protection, why doesn't the executive? Excluding cases of bribery, which were long prosecutable at common law, judicial immunity shields a judge from indictment for any act done by him sitting as a judge. Otherwise, the person who just gets elected as like the local prosecutor is the most powerful person in the whole entity. They just prosecute whoever they want. Yeah, I'm just going to prosecute all the judges who oppose me, and I'm just going to prosecute all the Congress people who oppose me. It's kind of obviously insane. So president's official acts are equally, if not more so, immune. And 7th, policy considerations rooted in the separation of powers support immunity, saying the president handles especially sensitive duties. The presidency requires bold and unhesitating action. Threat of prosecution in the future risks crippling that, lest the president be harassed by hundreds of prosecutors like Fannie and Tish in many enclaves throughout the country. Now they say, given the existence of criminal immunity, the scope of immunity should extend to the outer perimeter of the president's official responsibilities. And applying these principles, all 5 types of conduct alleged in the indictment fall within the outside perimeter of Trump's duties. So he should be immunized. And again, they're all going to say on the left that this is absolute immunity. And that's not what anybody is arguing. You see this word official? This has been used over and over again, but they want you to think that he can just, like he's a total tyrant. That's what he's arguing. It's not what he's arguing at all. And by the way, he's already gone through their due process and he was acquitted on it. That's why they're upset. So in addition, the impeachment judgment clause, according to the Constitution, it mandates reversal here because this incorporates a double jeopardy principle. A president who is acquitted by the Senate cannot be prosecuted for the acquitted conduct. They already were on trial and they won. The clause's plain meaning, its historical context, and its decisive weight of authority from key commentators all confirm that a single unelected prosecutor lacks authority to second guess the judgment of the United States Congress, the people's representatives who are there. Fannie can just indict. Merrick Garland can just bring in an unelected prosecutor who's not even affirmed or appointed by the presidency or confirmed by the U.S. Senate. Jack Smith, just bring him in, and then he can just wreck the election. Like he can just indict the president's political opponents. That's the type of process that they want in this country. So they tell us more about the argument in front of the Court of Appeals. They say the prosecution of President Trump, the entire thing is barred by presidential immunity. It's like a force field that immunizes him. Now they're going to cite this Fitzgerald case, the Nixon case, I believe, from 1959. They say this was the quote from that case. In view of the special nature of the president's constitutional office, they said a current or former president has, quote, absolute presidential immunity for civil damages for acts that fall within the outer perimeter of his official responsibility. Pretty powerful quote. So the question would be, why would that not extend into criminal domains? They say in addressing whether this extends to immunity from prosecution, this court should look back at the Constitution, look at its text, its structure, its original meaning, look at the common law, the historical practice, look at the Supreme Court's precedents and our immunity doctrines, and please, court, think about public policy, all of which I'm sure they'll explain for us here. Now, all these authorities point in the same direction. The president, in this case Trump, had absolute immunity from criminal prosecution for acts within the outer perimeter of his official responsibility. So it was in the job description and it was his official responsibility. Now they say, we know the separation of powers requires this. And I think this is important. First, they tell us, as emphasized in the Nixon-Fitzgerald case, the doctrine of presidential immunity is rooted in the separation of powers. The president operates and occupies a unique constitutional scheme, and absolute immunity is predicated on his official acts. It's incident to his unique office. Under the doctrine of separated powers, neither a federal nor a state prosecutor nor a state or federal court may sit in judgment over a president's official acts. Those are the presidency's alone, not anyone someone else's. We elected the president, not you, Liz. This grant of authority establishes the president as the chief constitutional officer of the executive, entrusted with supervisory and policy responsibilities at the highest of echelon. The president's unique status distinguishes him from other executive officials. And this is a point I've been making here for a long time. You've heard me belabor this point, but the president is the commander-in-chief. The president has the opinion clause power. The president has the pardon power. Okay, these are all very unique things that are to the president and the president alone. So when they say no one's above the law, literally he is. Like, I hate to say it to you, but like, read it. It's there. The immunity of the president's official acts from judicial second guessing has been treated as self-evident and foundational since the dawn of the Republic. Chief Justice Marshall wrote about this in Marbury versus Madison. He said, hey, by the Constitution of the United States, the president is invested with certain important political powers, in the exercise of which he is to use his own discretion and is accountable only to his country in his political character and to his own conscience. That's a big thing for the courts to say at that time. That's given the president a lot of power. Now, the acts of such an officer, as an officer, can never be examinable by the courts because you're substituting the courts for the presidency. It's like a moment of tremendous restraint even for Marshall and the courts to find this. It's like, whoa, we really can't do much, you know? We can't substitute this. Like, we're not going to convict him on that stuff. Justice Story agreed, citing Marbury for the proposition that the judicial branch lacks authority to sit in judgment over a president's official acts. In the exercise of his political powers, the president is to use his own discretion, is accountable to only his country and to his own conscience. Okay, the people who voted for the person can decide what to do with that person. We get to decide. We don't get some special interest groups funded by George Soros who get to remove him from the ballot and decide for us. Or Jack Smith being appointed by Merrick Garland via Joe Biden to come and decide the election for us. They don't want us to make the decision. They don't want Trump to be held accountable to the country because the country's not going to hold him accountable for a 4-hour riot, which was orchestrated, in my opinion, as a security failure, allowing this to happen, essentially. And don't take my word for it. Listen to Stephen Sund, former Capitol Hill chief of police, who makes that argument. They say the president and his decision in relation to these powers is subject to no control, and his discretion when exercised is conclusive because that was the role of electing that person. Thus, the judicial branch cannot require the president to exercise his executive power in some judicially prescribed fashion. Justice Scalia was concurring on that one, saying that an attempt on the part of the judicial department of the government to enforce the performance of the duties of the president might be justly characterized in the language of Chief Justice Marshall as an absurd and excessive extravagance. Otherwise, the courts are in charge. So they tell us Congress is the legislative department of the government. The president is the executive department. Neither can be restrained in its action by the judicial department. That's what co-equal means. It's incompatible with his constitutional position that the president is going to be compelled to personally defend his executive actions before a court. It's crazy, but we're doing that right now. The same principles, they argue, foreclose a criminal prosecution of a president for his official acts. Now they continue. The impeachment clause also presupposes immunity. Second, the text of the Constitution presupposes criminal immunity. For example, the impeachment clause, in it says that judgment in cases of impeachment shall not extend further than to removal from office. So Congress is only going to punish you to get you out of office. But the Constitution says this, Article 1, Section 3, Clause 7. I don't know that Chutkin read it. But the party convicted, ED, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. It's clear as day. You got to be impeached. Then if you're convicted, you're subject after the ED to additional punishment. But Trump was acquitted. They don't like that. So because the Constitution specifies that only the party convicted in the Senate may be liable, a president who is not convicted may not be subject to criminal prosecution. Antonin Scalia wrote that. Shout out, Ray, you rest in peace. Now, as Justice Alito also recently noted, the plain implication of this clause is that criminal prosecution, like removal from the presidency, is a consequence that can come only after the Senate's judgment. And that is in a case where Alito is dissenting. Now, this is how Hamilton explained this. He wrote this in the Federalist Papers. He said that a president is at all times liable to impeachment, trial, and dismissal, but any punishment must come only by subsequent prosecution in the common course of the law. Any other punishment, right, needs to come after the actual impeachment and conviction. Thus, as the Supreme Court has often stated, impeachment, not criminal prosecution, is the principal check against a president for malfeasance in his official duties. That's the tool that we have, but that tool didn't work for them, and so they needed to invent new ones. because they're cheaters. Now, early constitutional authorities even confirmed this. We know Alexander Hamilton wrote a lot about this. Marbury and General Lee also wrote about that. Not Robert E. Lee, but General Charles Lee, Attorney General. And they also talked about it. Common law supports this as well. The Supreme Court speech and debate cases make this clear. They say there was a privilege of legislative immunity that was not born of a desire to avoid private suits, but rather to prevent intimidation by the executive and accountability before a possibly hostile judiciary. Protection of the presidency from other political factions and a potential hostile judiciary is also reflected in the case law. We regard immunity as being rooted in separation of powers. So civil immunity without criminal immunity is like a lock without a key, a bat without a ball, a computer without a keyboard. In other words, it's not especially sensible. Now, they tell us that Democrats have wrecked 234 years of history, saying Fitzgerald also consulted the presuppositions in our political history. Here are the facts, Jack Smith. From 1789 to 2023, no president was ever prosecuted for his official acts, despite centuries of motive and opportunity to do so. They say Trump is the worst ever. The worst ever, really? Now, the 234-year tradition of not prosecuting presidents for official acts strongly supports the existence of immunity. For example, American history abounds with examples of presidents who were accused by political opponents of committing crimes through their official acts. These include, among many others, John Quincy Adams. You remember the corrupt bargain. He appointed Henry Clay as Secretary of State in exchange what they say, I think, is for the presidency. That's from the presidential election in the corrupt bargain. President George Bush, he made false claims to Congress that Saddam Hussein possessed stockpiles of weapons of mass destruction. Obviously, that wasn't true. Thousands of people were killed as a result of that. Thousands were dead, okay? We had the Capitol Hill police shoot and kill a woman named Ashley Babbitt on January 6th. We had Roseanne Boyland beaten and die, and others were killed there. But thousands were killed and went to die as a result of George Bush. And what about President Obama when he authorized a drone strike that targeted and killed a U.S. citizen and his teenage son, also a U.S. citizen? Is that any due process there? Is that a crime? How come he's not being prosecuted by a special counsel for killing an American citizen, two of them, via a drone strike? Trump didn't do that. Trump said fight like hell on a rigged election, and that was enough. In these cases, the president's political opponents vehemently accused that president of criminal behavior for his official acts. And I grew up, man. I remember after 9/11 with all the Bush stuff. Remember, Cindy Whack Job out there, and they were, all of them were demanding prosecutions, right? And they were all just saying that this was absolutely criminal. And, maybe they're right. Turns out maybe it's right. Maybe they are. Maybe they should have been indicted. I mean, if this is the standard, we're just going to start indicting everybody. It's like, okay, the theory was that you don't do that. Okay, the theory was you give the executive the benefit of the doubt. Maybe that's a mistake. But in each case, those outraged political opponents, they eventually came to power, but no president was ever prosecuted until this year. The Democrats and the DOJ created and shattered an unbroken tradition of not exercising the supposed formidable power of criminally prosecuting a president for official acts. Despite ample motive and opportunity to do so over centuries, it implies the power just simply does not exist. Now, they say that the lack of historical precedent coupled with the breadth of the authority that the special counsel now claims is a telling indication that the authority does not exist. They tell us that other immunity doctrines also support criminal immunity. We've got legislative immunity. Congress has immunity. There's judicial immunity. Sitting as a judge. If you're sitting as a judge, you're not going to be indicted for doing stuff that's within the purview. Likewise, legislative immunity. They've got it. A doctrine rooted in common law. If it's within your official act, you're immune from that. Cases where prosecutors have brought criminal charges against judges for judicial acts are exceedingly rare, as we've seen. The district court concluded there is no judicial immunity from prosecution for judicial acts, but this is incorrect, as is what Judge Chutkan said. So Judge Chutkan cited this, and they say she cited this wrong. Sorry, Judge. Read the case. At common law, judicial bribe taking, or bribe extorting, taking a bribe is not a judicial act. Clearly not. So sorry, Judge, bad case law. We also got other policies that support this. The president has especially sensitive duties that they need to take care of. Under the Constitution, we've already recognized that. Supreme Court has also said unequivocally the president needs to take bold and unhesitating action. That's why we have a presidency. Crippling and deterring executive action is a concern. If a president can have a bunch of prosecutors nipping at his heels, then he can be harassed by political prosecutors who are bringing vexatious actions, saying the district court and her reasoning, Judge Chutkan's reasoning, is just not convincing. It's not. The district court disagreed with our analysis. She said it's not convincing, but however, Chutkan simply failed to address many of his arguments, so its own analysis erred. Chutkan said that no court has ever accepted presidential immunity from criminal prosecution for official acts, but no court has ever addressed the question. That's why, Judge, it's a new thing. You guys shattered this. As noted, the 234-year tradition of not prosecuting presidents implies that they don't exist. So Chutkan's like, well, we've never seen anything like what you're asking before. I can't believe you'd even ask me for that. We've never seen anything like that before. And you're like, yeah, hello, Judge. It's because it's never happened before. Hello, wake up. The district court reasoned that the absence of an express provision in the Constitution granting official immunity implies that no immunity exists. But that's strange, because that would mean that the civil suits that the Supreme Court have already found the president does have immunity from, I guess the Supreme Court is wrong. Is that right, Judge? No, you're wrong. Fitzgerald upheld absolute presidential immunity from civil liability for official acts in the absence of explicit constitutional guidance. And so they say, moreover, Chutkan's logic, if you can think there is any there, would invalidate other well-established immunity doctrines that are not already well spelled out. We know what Alexander Hamilton said about this. We know that a lot of this has been universally accepted until this year, and the district court misapprehends all of the historical and legal context. Judge Chutkan has a difficult time with this. In 1973, in the year 2000, questions arose about whether a sitting president might be criminally charged for acts that included private conduct. President Nixon's alleged involvement was in a range of potentially criminal private conduct, and Clinton's alleged perjury and obstruction of justice in a recent private lawsuit was also based on official conduct. But the legal issue addressed is whether a sitting president enjoys complete immunity from any kind of criminal indictment, even for private crimes. The question whether a sitting president has complete immunity from criminal process is distinct from whether it's process for immunity based on official acts. So we're distinguishing between different categories here. Going through their analysis, and the Office of Legal Counsel wrote a memo, and they tell us, carrying on, that Chutkan has made the argument that if she grants criminal immunity here, it would lead to perverse results. This is a dumb meme that you've heard a lot on MSNBC. They say presidents can escape the punishment for official act crimes in marginal cases, right? This is the Trump can just murder everybody before he leaves office, and then he's immune. They say the memo addresses very similar concerns about potential under-enforcement, and the concerns do not outweigh the needs of the president's office and functions, saying the Constitution establishes a powerful structural check to prevent political factions from abusing the formidable threat of criminal prosecution. And under the Constitution's balanced approach, a president may be prosecuted, but only if he is impeached, tried, and convicted by the Senate. And so the Constitution opens the door to those prosecutions, but it requires a strong political consensus. It requires the participation of the political branches, including a supermajority of the Senate and the Republic's traditional cooling saucer before drastic actions can be taken, which is why they wanted this to go so fast when Trump was right after January 6th. They went fast because they didn't want people to think about it. Accordingly, the Supreme Court has repeatedly emphasized that impeachment, for which Trump was acquitted, provides the principal check to deter a president. Now, the mere possibility of under-enforcement in marginal cases does not mean the president's criminal immunity evaporates. Every structural protection of the Constitution creates the possibility of under-enforcement, but that's a feature, not a bug. We're trying to stop this from political hacks, and it worked for 234 years. The district court reasoned that the Supreme Court largely rejected similar claims, but Nixon addressed a far less serious threat to the presidency. This is much more serious because these are official acts, and it's a criminal indictment, and they're seeking imprisonment directly against the president himself. Now, they carry on. They say the district court emphasized the strong public interest, you've heard this line too, in criminal proceedings. But when it comes to the prosecution of a president, the Constitution, they say, strikes a balance that gives grave weight to those interests. It allows a president to be prosecuted for purely private acts and even for official acts after he was impeached and convicted. The district court had no warrant to rebalance what the Constitution has already balanced, saying that She says, Chutkan says, despite other vehement disagreements in the Fitzgerald cases, all 9 justices unanimously endorsed the denial of criminal immunity with respect to former presidents. Not so, they say, Judge. Fitzgerald merely noted that the exercise of jurisdiction held warranted over presidents to vindicate the public interest in an ongoing criminal prosecution, and it recognized that there is a lesser public interest in actions for civil damages than, for example, in criminal prosecutions. But it didn't extend all the way to whether criminal immunity exists for criminal prosecutions, and the concurrence supports that, they argue. Citing the OLC, they say that Chutkan is relying on some other things that are wrong. And they make in subsection C here another argument, saying that the alleged conduct in the indictment falls within the scope of Trump's official responsibilities. It's within the hula hoop. It's within the Engeron. Now, because the district court held that criminal immunity does not exist, it did not address whether the 5 types of conduct fall within the outer perimeter. They say in assessing whether immunity does apply, courts must look at the nature of the act itself. Under these standards, all 5 types of conducts that we talked about are official act. They're all President Trump's efforts and duties. They all are advocating for the integrity of a federal election. They say first, Trump's public statements and his tweets are clearly within the outer perimeter of his presidential duty. These are matters of presidential concern. This is especially apparent in Trump's tweets, saying that he's got evidence about this stuff and his public statements are official statements. Second, President Trump's communications with the DOJ, he was acting as a president. Those are literal presidential acts. The Constitution says the president shall take care that the laws be faithfully executed. And deliberating about whether to put a cabinet level officer at a certain position is a presidential duty, not even arguable. Third, communicating with state officials. Trump made phone calls to guys like Brad Raffensperger. The president's take care duty, as we have seen, also includes rights and duties that are going out of the Constitution itself. These are the implied powers. We talked about the first ring, which is explicit powers. The outer ring would be the implicit powers. And then you have kind of, maybe a gray area that's implied from stuff you haven't, discussed yet, because situations change. Hindsight's 2020, right? We're always giving the president, which, by the way, it's supposed to be like the country's president. This includes taking steps to ensure the integrity of federal elections, and the president was doing that. And fourth, talking with members of Congress, including the vice president, as his capacity as the president of the Senate, is clearly a constitutional duty. Article 2 says he can do that specifically. And fifth, organizing contingent slates of electors is the same thing. They fall under the presidential duties because his duties extend to all rights, duties, and obligations growing out of the Constitution itself. Those are plainly within his duties, and so he is immune. They say the prosecution is also barred under the impeachment clause and due to the principles of double jeopardy. We know what the Constitution says about this, and they make a concession. They say their reading is to be avoided. This judge, who's better, is persuasive. When he was writing about this, he said that the English House of Lords could pronounce a full and complete sentence, and an acquittal would further bar prosecution. Okay, so even the English get it. Shout out to our friends in the UK. Now, the district court, they pointed to a 1973 OLC memorandum, and they say a different interpretation. It rests on the assumption that framers and ratifiers relied on formulations of double jeopardy that restricted it to cases where the defendant's life was at stake. Okay, so double jeopardy doesn't apply to all crimes, only like death penalty cases, which would be insane. But if that's what founders believed, there would be no reason to say a convicted officer could be prosecuted. Double jeopardy would be out of the picture. It also assumes the founders departed from the British model explicitly in one way, but implicitly in another way, and that's unlikely too. And so the framers discussed impeachment. The punishment which may be the consequence of conviction upon impeachment is not to terminate the chastisement of the offender. After having been sentenced to a perpetual ostracism from the esteem and confidence and honors and emoluments of the country, he will still be liable to prosecution in the ordinary course. After, okay, so political first, then elsewhere. Then there's another one, James Wilson. He made another statement to the same. You got to go political first and then elsewhere. Now, Madison underscores this. He cautioned against newfangled and artificial treasons, which have been the great engines by which violent factions, the natural offspring of free governments, have usually wreaked their alternate malignity on each other by allowing people to say, he's an insurrectionist. Just artificial treason, okay? Just insert the word insurrection. Madison got it too. They were, pretty intelligent. They knew where all this was going. And the Democrats who don't read history are just like, well, he's an insurrectionist though. So artificial insurrections is a nice tool of tyrants. By requiring widespread political consensus consensus within the U.S. Senate, the historical cooling saucer of the republic, before a president can be criminally prosecuted, protects the presidents from newfangled and artificial treasons. And contrary to Judge Chutkan, the Supreme Court has repeatedly affirmed that impeachment is political, and so is the principle and constitutionally prescribed method to address presidential malfeasance. And so Trump's defense continuing says, the impeachment judgment clause thus protects presidents from harassing criminal prosecutions by prosecutors and requires Congress to first make a political judgment that the president should be convicted. If, as here, the Senate acquits the president, the Senate has necessarily concluded that the president should remain in office and is not disqualified from service. For a prosecutor like Tishy or Fanny or Jack or Molly or Tom or Jay Bratt to conclude otherwise undermines that conclusion. Indeed, a successful prosecution voids it and arrogates itself to a judgment the Constitution reserves to Congress. And so, thus, President Trump's acquittal by the Senate bars prosecution for the conduct that's been alleged in this indictment. Chutkan misses the whole point. The preclusive effect here is from the impeachment judgment clause, which incorporates double jeopardy, but double jeopardy tests wholesale. Saying further, the acquittal reinforces Trump's immunity argument, whereas here, the question is the amenability of the president to prosecution for an official act. The politics and political concerns are at their apex. Before any single prosecutor can ask a court to sit in judgment of the president's conduct, Congress must have approved of it by impeaching and convicting the president, and that did not happen here. And so President Trump has absolute immunity, saying Judge Chutkan's order should be reversed and the case should be remanded back to Judge Chutkan's courtrooms with the instructions to dismiss the indictment with prejudice. In the alternative, the court should uphold criminal immunity and remand to the district court to apply the doctrine in the first instance. If this court affirms the district court in any respect, Trump respectfully requests you stay the mandate, including possible en banc proceedings or review to the Supreme Court. Signed by John Lauro. So if we don't win here, we're going up to SCOTUS. John Sauer also signing off on this, the team on behalf of Trump doing the appellate work. And you can see this one is in the D.C. Circuit Court of Appeals, and it's a nice one. And we like to see that materializing and working its way through the courts. I think they are great arguments. I think it's just logical how it works. And for them to upend that is very problematic for the future of the country. Hopefully the courts agree. This is Joe Biden, who got asked about presidential immunity, and he doesn't have much to say because he doesn't have much mental capacity left. But this is what he was saying when he was asked, should any president be immune from criminal prosecution? Which is a very open-ended question. Okay, what do you mean? So like no immunity at all? Here's what Joe says. I don't know if he's actually responding to this question or if he just can't think of anything. This is Joe.
President is absolutely immune from criminal prosecution. Any president at all.
I can't think of one.
Okay, I can't think of one. So I don't know what he's answering. Should any president be immune from criminal prosecution? Well, not Trump, I guess. You can't think of Barack Obama for drone striking American citizens? Should he have immunity from that? Should we just have total indictment for all past presidents? Okay, so all right, that's Joe Biden, so not much from him. Now this guy is saying that Trump's argument for absolute immunity, which is never an argument that he's made. We have read every single stinking motion here, happily, and never once have we ever seen Trump say, I deserve absolute immunity for everything that I've ever done or thought or said. That's what they were giving to Hunter, not Trump. That's what they were working out for him, that everything from those years was blanket immunity. So now we're hearing from this guy who's saying that Trump is making that argument and the Supreme Court is going to reject that argument, which, by the way, I agree. It's like, man, you can set up these straw men all day. Is that all you need to do to go on ABC? Just make up something that no one's arguing and then disagree with that? I totally think the Supreme Court's going to deny that. Yes, I also agree. I think the Supreme Court is not going to repeal the 13th Amendment. Yeah, wow, brilliant legal analysis. I told you, the Supreme Court didn't repeal the 13th Amendment. You're like, oh, congratulations. You know, obviously that was never going to happen.
Overnight, President Trump's legal team filed a brief with the appellate court here in Washington saying the election interference case should be thrown out, again, because of the immunity. Was that expected? And is that part of what you were talking about a few moments ago?
Look, they're searching for every opportunity to delay, to make broad sweeping claims, to prevent these trials, as Sarah was saying.
and she has a good point on all 4 trials, prevent them from happening before the election. And I think any sweeping argument made to any court, interim, appellate, Supreme Court, on the part of Donald Trump has to be expected. The sweeping claims of absolute immunity, I think, will ultimately, even with this Supreme Court, not hold, but it's going to take a while to get there. That's the problem.
Oh my gosh. He's never, ever claimed that he needs absolute immunity, even with this Supreme Court. What kind of a ridiculous thing is that? Trump has never made that argument one time. Of course, yeah, because it's an insane argument. They're just saying if it's within the outer perimeter, it's fair game, unless he has been impeached and convicted. Obviously, he has not. So we got some interesting people over there who are just making up arguments and having conversations with themselves. But this guy's a little bit more intelligent. His name is James Trusty, and you're familiar with him as Trump's former lawyer. And we're going to listen to him explain a little bit about what he thinks about SCOTUS and these appeals, having worked for Trump.
In the federal classified documents case. So just to get your thoughts on this, now that the Supreme Court has refused to fast track the arguments, could this give Trump's legal team a leg up, and how so?
Well, I don't know if it gives a leg up substantively. We don't know how they're going to rule in terms of the immunity itself, but it certainly jeopardizes the March trial date. And I think that's really the story here. You had a prosecutor in a very unprecedented position saying we have to have a speedy trial. A speedy trial right is a defendant's right. It's very unheard of for a federal prosecutor in any district, and I was a federal prosecutor for 27 years, to announce that they've got this specific speedy trial interest where it has to be tried by date X. That was weird territory. It did not pass the sniff test when it came to the basis for an expedition for the Supreme Court, and I think they made the right ruling.
So the question of immunity, as you note, is the larger issue, not the schedule. It's going to probably end up at the U.S. Supreme Court regardless. Do you have any idea of what they might do when they review the case?
No, I mean, look, a lot of lawyers would go poor betting on that.
What's your guess?
Well, my guess is the first stop is that the Court of Appeals will probably say there's no immunity at all. I'm not particularly struck by the double jeopardy argument. That one seems like it's a little bit of a stretch to say that the legal impact of an impeachment process has any real carry on.
That's Trump's argument that it's legal.
It's it looks like a secondary argument, but I think the primary argument's interesting because, you could see the Supreme Court getting to it and deciding to have a bit of a carve-out approach. If the activity of the president at the time was really connected to core functions, maybe that's immunized. You wouldn't want to have it where a president could have a drunk driving incident or could go beat up Jake Tapper for no real reason.
Well, hang on a minute on that second one. Okay, only kidding. But that's not what anybody's making. No one is making that argument, James. Okay, everybody would say getting a DUI or, backhanding Jake Tapper would be not within the official duties, probably for Jake. But that is obviously criminal. He could be indicted for all of those things instantly. You don't have to go through all of this additional procedure for something that is obviously outside of the bounds.
And say that they're immunized. So there could be a little division of whether it's something that's really in the wheelhouse of being the president versus being frolic and detour, as they call it legally. But I have no idea. I think, it's new territory. We have no way of really knowing whether this is going to be something that splits on philosophical lines or not. And we'll have to wait and see for a while, it looks like.
Of course, we also have to wait to see if the U.S. Supreme Court is going to take any action when it comes to Donald Trump's anticipated appeal of the ruling by the Colorado Supreme Court. The Colorado Supreme Court earlier this week ruled that Donald Trump cannot appear on their ballots because they judged him to have participated in insurrection, and according to the 14th Amendment of the U.S. Constitution, is therefore ineligible. Do you think that Trump's legal team will, well, first of all, I assume you think they're going to appeal. And how do you think they're going to approach that appeal, and do you think they'll be successful?
Well, it's a petition for certiorari for the Supreme Court, and the percentages in general are pretty low about the Supreme Court taking these cases. I think they'll take it. I think this is an outcome.
Because it's a state Supreme Court decision.
For a variety of reasons. You've got a
election.
state Supreme Court
ruling
on something that could be viewed as a strictly federal question. You've got all these issues about interpreting Article 3 of the 14th Amendment, whether it even applies to the president. And the district court, although they were no friend of President Trump, they said that's a problem here.
Right. They said he committed an insurrection, but he's not covered by the 14th Amendment.
Right. It's not the sexiest kind of legal reasoning, perhaps, but there's something to it. And that's, I think it was Ty Cobb, who's no big friend of President Trump at this point, was announcing this is a 9-0 winner when it goes to the Supreme Court. So there's kind of foundational or procedural issues that they could hang their hat on. And that's probably safer territory for getting like an 8-1, 9-0 opinion out of the Supreme Court if they rule on more of a procedural or foundational basis. But I got to tell you, in terms of the merits of this thing, the expedited trial that he had included basically embracing the bulk of the J6 committee as substantive evidence of insurrection. I think that's a horrible precedent. And then they also relied heavily on a sociology professor who is essentially saying that he is the Trump dog whistle whisperer. Yeah. That although Trump said things like go peaceful and patriotically, it really meant unpatriotically and violently. And the thought that any court is deciding something this fundamentally important with that kind of psychobabble is really an extraordinary moment.
So who, in your view, is the right one to judge whether or not Donald Trump did participate in an insurrection?
Well, there's a real easy out here,
people.
which is if he is convicted, that could be the obvious basis.
No.
But Jack Smith's
for-
not trying him for
I understand.
inciting
Well,
insurrection.
he's
Right.
trying an insurrection case, but
good
not
point,
calling it
Jake.
insurrection. If
Good
you look at the
point,
most
Jake.
recent pleading, it's like we're going to put everything we can about President Trump disliking, electoral results. But at the end of the day, that seems to be a more solid ground, and that could be where the Supreme Court goes as one of these foundational issues. That we're not going to have mini trials on insurrection. You're either convicted of it or you're not, and that would be obviously a huge win for the president if they go that way.
All right.
So they say Trump is
the
an
rare-
insurrectionist. Jack Smith gets convictions on all of the charges, but not insurrection. Then Trump escapes the insurrectionary conviction under SCOTUS, and he escapes criminal liability. Now, I don't agree with James Trusty's take on the double jeopardy portion of this. I think that is cut and dry logic. You get somebody, you impeach them first to make sure it is not political. Then when you're sure that it's not political, because 2/3 of the Senate votes to convict, at that point, it's fair game. You got to have that safety valve. And so I don't know why that is not landing with some people on that analysis, but we'll be here, my friends, to continue to cover this. Of course, we're going to have a response from Jack Smith, and then Trump will issue his reply, and we'll have a lot more filings to attend to out of the DC Circuit Court of Appeals. And so wherever it is you're watching this, my friends, thanks for subscribing. We're covering all of the Trump cases. It's going to be a lot. I was looking at the calendar. We've got a lot of deadlines coming up here, a lot of response deadlines. Trump's got Florida deadlines, Fannie, RICO deadlines. And so we'll be here covering it. Thanks for sharing the channel with a friend or family member. Thanks for sharing a short form or a segment with somebody. Say, hey, did you know what they're doing to Trump here? Look at this. Here's what the motion says. And we'll appreciate seeing you and them here on the next one.